A very good morning to all my dear students. Today we are going to discuss about the concept of restitution as provided under the Code of Civil Procedure 1908. To start with the today's lecture, I just want to recapitulate what we have done so far in this subject. We have already discussed about the concept of judgment, decree, and order, and also have gone through the various other definition mentioned under the section 2 of Code of Civil Procedure. Further, we have discussed about the two important doctrines mentioned under the Code of Civil Procedure, that is, the principle of res sub judice and the principle of res judicata. We have also discussed about an important concept of caveat also. Now, we are going to start with the principle of or the doctrine of restitution as provided under section 144 of Code of Civil Procedure. My dear students, before I now I will straight away go to the set topic. The definition, as far as the doctrine, as far as the word restitution, the said word or the said expression has not been defined in the Code of Civil Procedure. It means an act of restoring a thing to its proper owner. This is the literal meaning of restitution. In other words, restitution means restoring to a party the benefit which the other party has received under a decree subsequently held to be wrong. It does not create a new right in favor of the party who has suffered the loss because of the wrong act committed by the other party to him. In Halsbury Law of England, it is stated that any civilized system of law is bound to provide remedies for cases of what has been called unjust enrichment or unjust benefit, that is to prevent a man from retaining the money of or some benefit derived from another which it is against conscience that he should keep. So from this we may infer that this doctrine has been carved out so that there cannot be any unjust enrichment in the hands of an aggrieved party. Furthermore, this concept is also having resemblance with the section 70 of Indian Contract Act, where a person who has found some property on a road and thereafter takes that property without looking for the real owner, then in that case it may be a case of an unjust enrichment. Similarly, the doctrine of restitution is also having relations with the another section of Indian Contract Act, as you have already read about that minor's contract is void, but by virtue of section 33 of specific relief act, whereby the voidable or the void contract under which a party who has committed a wrong, and if he has taken any benefit, then under the contract it must restore that profit to the person to whom he has incurred or has caused injury to him by his act. Further, this doctrine of restitution, as given under the Contract Act, we may have an important case, and we have already read an important case with regard to it, and that case is Leslie versus Shield, wherein the court at that particular point of time held, even though the minor's contract is void, but in but with regard to the act committed by that particular person, if he has that particular property, that is the minor, then that property may be restored to the real owner, but he cannot recover the money consideration from him, because at that time it was judges were of the opinion that it will tantamount to the enforcement of contract, which is void as per section 11 of Indian Contract Act 1872. So from this example, we may infer that there is an there is an interplay between the Contract Act as well as the Code of Civil Procedure. Now, we will go further. What is the object behind this particular doctrine? This particular doctrine is based upon another legal maxim known as actus curiae niminem gravabit, means the act of the court shall harm no one. And Lord Keynes once said that one of the first and the highest duties of all court is to take care that the act of the court does not injure the suitors. So, from this, we may infer that this is based upon an equitable principle, and it is based upon justice, equity, and good conscience. And therefore, the law imposes an obligation on the party who received benefit of an erroneous judgment to make a restitution to the other party for what he has lost, and it is the duty of the court to enforce this obligation. Now I will give you an example with regard to it. A obtains a decree against B for rupees 10,000 and recovers the amount in execution. The decree is subsequently reversed in appeal. B is entitled under section 144 CPC to the refund of the amount together with interest up to the date of repayment, though the appellant decree may be silent as to the interest amount. So now I will move further and give you another example with regard to the same. A obtains a decree for possession of immovable property, and in execution of the decree obtains the possession thereof. The decree is subsequently reversed in appeal. B is entitled under this section to restitution of the property, even though there is no direction for restitution in the decree of the appellate court. Now we will move further. What are the essential conditions of the restitution? The restitution must be in respect of the decree or order which had been reversed or varied. So, the doctrine of restitution, that is the doctrine of relation back, must be applicable in those cases wherein the decree has been reversed by the higher court of the trial court. Second, the party applying must be entitled to benefit under the reversing decree or order. Second point is the party applying must be entitled to benefit under the reversing decree or order. And thirdly, the relief claimed must be properly consequential on the reversal or variation of the decree or order. So these three are the essential elements of doctrine of restitution. In other words, in other words, there must be an erroneous judgment. The benefit of that erroneous judgment has been received by one party, and the erroneous judgment has been reversed, set aside, or modified by the higher court. If these conditions are satisfied, the court must grant restitution to the aggrieved party. It is not discretionary but obligatory on the court to perform its duty, as it is based upon doctrine of equitable principle, that is just equity, justice, equity, and good conscience. Now I would like to put some highlight on the nature and scope of section 144. Section 144 of the code embodying the doctrine of restitution does not confer any new substantive right to the party not available under the general law. The section merely regulates the power of the court in that behalf. It is the paramount duty of all the courts to ensure that they do not cause injury to any litigant. So, this doctrine is given under CPC is primarily to protect the aggrieved party from the act of the court itself, whereas the other provisions give remedy to the aggrieved party from the acts of the other party, but not from the court. But this particular section gives the protection to the aggrieved party from the acts of the court only. Now, who may apply for restitution? Meaning thereby who are the parties to the restitution's application. Number one, it is the parties and it includes their beneficiary under the final judgment, but it does not include trespasser, as no restitution can be sought against him. Against bar of suit, section 144 clause 2 puts bar on separate suit in cases where restitution could be claimed by an application under this section. So now I will move further. Against whom the restitution can be granted? Restitution can also be granted under this section not only against the party to the litigation but also against his legal representative. Example, transferee pendente lite. As you all are aware, transferee pendente lite, the concept of the same is given under section 52 of the Transfer of Property Act. attaching the decree holder, etc. Section 144 applies only to parties or their representatives and does not apply to surety. So, surety will not be covered under the concept of or under the expression of restitution application. So, they cannot be the part of this. Who may grant restitution? An application for restitution lies to the court which has passed the decree, which has passed the decree or made the order. Is there any format of this application? No specific format has been prescribed by the court for making an application for restitution. Whether the doctrine of res judicata would be applicable? Yes, the doctrine of res judicata would be applicable to the executing proceedings as well. So these are some of the concepts which I am just telling you in today's lecture, and will give an explanation in my further lecture, or series. This is what I am going. I have to apprise you, and this is all about today's lecture. Hope you have learnt a lot from it. Thank you very much. In my next lecture, I would like to tell you about the inherent powers of the court. Hope you have a good day ahead. Thank you very much once again.